This is the plaintiff, Janin Sayed. She says she was looking to rent office space for her chiropractic practice, and she gave the defendant a deposit, which he now refuses to give her back. He made her sign the contract, and after she signed it, he added deposits are non-refundable. He can't do that. She's suing for $1,000. The money she's out. This is the defendant, Gurpal Aluwalia. He says the plaintiff knew full well deposits are non-refundable because it was clearly written on the paperwork she signed. He lost out due to the plaintiff's change of mind, and he isn't returning a thing. He's accused of illegally altering a contract.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case in the docket. The plaintiff says she rented office space from the defendant, put down a deposit for her chiropractic business. It didn't work out. The guy changed the contract and now won't give her a refund. But the defendant says it was clearly written on the contract that deposits are non-refundable when she signed, and he owes her nothing. It's the case of, you're breaking my back.
Thank you, Douglas.
You're welcome.
Okay, Ms. Sayed, you have a chiropractic and natural wellness center, and you are suing Mr. Aluwalia and his company because they won't return a $1,000 deposit you placed on office space there. Tell me what happened.
Okay, well, on April 29, 2021, I was searching for an office space on the internet. I saw one that I really liked on Craigslist. So on May 4th, I went to see the office space. We liked it. And I told them, please, tell us like what we need to bring in because we really like it.
Did you pay a deposit?
Yes. So on May 4th, I gave him a deposit for $1,000. And he also let me sign a piece of paper. It says, something about like I left the deposit until the lawyer reads it, a legal binding contract and so forth. So, so when I signed the paper, so then he said he took the paper back for me and he wrote something on it. I didn't see what he wrote on it because I thought it was a date or his signature, but I ended up making a copy of the check and also the paperwork.
According to you, after you signed it and gave him the money, he added the words right in front of you, non-refundable?
Yes, that's correct.
So according to you, when you signed it, those words were not there?
No, it wasn't there.
And according to you, he adds them right in your presence?
Yes.
Well, if you saw him adding them, why didn't you snatch it back and say, forget it, I don't do business this way?
During that time, I was just very excited about the office space.
Tell me what happened between then and now.
I told him that, because at that time I was very sure that I was going to take that office. But then when he gave me the contract, the sublease, he had, I think, forwarded to my lawyer. And then he gave me a call back and told me this lease is not in your favor. It's a money pit. You're responsible for everything. The repairs, the pipes, the leaks. If a glass is broken, you're responsible for that. There was just a lot of things. Okay. And then he told me after 3 years, there will be a 6% increase in the rent.
Right. And are you saying that none of that was discussed with you beforehand at the time that you gave the $1,000?
No, he had texted something that the first year was going to be $2,200. The second year is going to be $2,300. The third year is going to be $2,400, and then 6% afterwards.
He had told you that?
Yes, he did.
So what were the surprises for you, not for your lawyer, but for you? What in the lease was a surprise? Anything, or no, that's what you and he had discussed? You just hadn't had a chance to talk to your lawyer?
Yes. He was telling me you would be responsible for any broken pipes, any leaks.
Is that something that you and the defendant had discussed verbally before he gave you the lease, or no?
No.
Okay. So that was new information to you, according to you?
Yes.
All right. Let me hear from you, Mr. Aluwalia.
First of all, when we met the first time, I'd already instructed her that I would need a deposit of some amount before I can start with the legal paperwork to give you the lease. She saw the place. She was happy with the place. She went, discussed, and then she called me back a couple of days later, and she saw it again. And at the second time, everything we discussed, I put it in a text and I sent it to her.
Okay, so let's see the text that you discussed and then the contract that you gave and see if there's a difference. Okay, so I see the April 30th text where you're saying all the paperwork and third year, 6%. Do you ever mention that, what she says, that all repairs are something she would have to do?
Yes, I did.
Where is that in the text? Because I don't see it in the text.
It's not on the text, but I told her she was trying to compare it, but because she was trying to compare an apartment that she's renting and doing her business out of to a commercial storefront. And I told her, commercial property, you're responsible for everything.
Let's see the lease that you provided, because it's all going to boil down to whether there's anything in the lease that's different from what was discussed. Now, your attorney looked at this and said, wait a second, you've got to pay for everything. And he or she found that to be shocking, that the landlord would not pay for any repairs. Correct, Ms. Sayed?
I did explain that to her.
Yes.
Is this a sublease, Mr. Aluwalia?
Yes, it is.
Did you ever tell her it would be a sublease?
Yes, it is. When I even spoke to her, and then it says right on the lease itself, it's a sublease.
No, I know the lease itself says it. I'm asking you, Ms. Saeed, did you know it was a sublease?
I thought it was a lease.
Did he ever tell you that he was subletting it, that he leases it from someone else? Did he ever tell you that?
No, he never told me that. No.
I did tell her on the second time we met. Yes.
Okay, besides verbally saying, yes, I did, no, I didn't, do you have anything in the binder or in a text or in an email to show that at the time that she gives $1,000, she is fully aware that this is a sublease and fully aware that she would have to pay for all repairs and you would pay for nothing? See, the reason this is relevant, Mr. Aluwalia, is because if you guys have an agreement and I pay a deposit and I hold you up by paying that deposit, you can't negotiate with anybody else. You can't rent it to anybody else. You know, deposits are typically non-refundable, whether it's written or not. The whole point of a deposit is to hold a place. How do you think it's going to be free for you? What, are you going to go around town putting deposits everywhere? So typically a deposit is non-refundable. I'm totally with you on that. Even if it hadn't been written in there, I would be thinking the deposit's non-refundable. The exception to that would be if all of a sudden when you hand her the contract, it has things you guys didn't discuss. Because then at the time of the giving you of the $1,000, there wasn't a meeting of the minds. There has to be a meeting of the minds. You can't sneak in things afterwards and say, okay, I guess you're not going to take it, but I'm still going to take your $1,000. You understand what I'm saying? You know, if it's an application fee, you need to be calling it an application fee. But if you're calling it a deposit, then I have to apply deposit law. You see? So exactly what, other than spitting out a lease, is there anything that you did based on her application in order to approve her? What did you do?
I looked at all of her paperwork and so forth, and whatever I know what you're saying about the verbal, but whatever we agreed on, I put it in a text. I know,
but I'm looking at the text and I am looking with my eyes at the text, and it doesn't say everything you're asking her to sign in the lease. It doesn't, right?
But if I put everything, that text message would be...
That's why a lot of times people won't call this a deposit. They'll call it an application fee. It probably wouldn't be $1,000. It'd be $500 until you hand over the lease. And then they say, yeah, I'm going to want this. And then you ask them for a deposit. Then they can't complain that you stuck things in the lease that they didn't know about and had never discussed with you. Oh. You know what I'm saying? Because it is relevant. Mm-hmm. Her lawyer did look at it and say, well, there's this expense and that expense. Wait a second. That doesn't look normal to me. This isn't customary or whatever. Her lawyer gave her a bunch of advice. She was super psyched about this. She wasn't trying to, just reserve it and gallivant around town looking for something else. I can see from the text that she's, do I need a permit to paint? The painters are coming by. She really wanted this place. But then, she pays a lawyer and the lawyer tells her, no, I don't think that this is in your best interest. This is a sublease. Did you know that you're responsible? I advise you not to. And then she says, okay, I'm going to follow my lawyer's advice because these are all new things. But just so we're all clear, I'm not sure I buy this. He added the non-refundable stuff. So don't think I'm falling for that because I'm not. But I still have to sit here, look at it and say to myself, all right, should it remain non-refundable if there are things that they never discussed sitting down there? So I would have to find that all those things were discussed by you guys. It's your word against hers on that. All right, based on what I'm listening to, I am going to order a refund of the deposit, $1,000 verdict for the plaintiff.
So the plaintiff prevails. She's going to get her money back after all, the deposit. Let's see what the defendant has to say. Mr. Ahluwalia, are you surprised at the judge's decision?
Yes, somewhat surprised. I mean, there's no way to discuss every little thing with the plaintiff. It is what it is.
It is what it is. Unfortunately, you got to give that money back. All right, Miss Sayed, how do you feel about the outcome of the case? What are you thinking right now?
I'm very satisfied with the outcome of the case. I just rented another office space in Rego Park, New York, and all I have to pay is the rent, the cable fee, and the phone. No taxes, no water bills. So, that was a surprise when my lawyer told me that.
Well, it's a good thing you took this to your lawyer. That was a smart move on your part.
Yes, correct.
Okay, you've learned a lot out of this, and hopefully you'll be happy in your new place for your new practice. All right, smart lady, Harvey. What do you think?
So, Doug, when people sign a contract, they never really think, oh my God, what happens if I have to sue them? And so they take a lot for granted and they think, oh, nobody's going to screw me over. So, I just really won't read it or whatever. That's obviously not the case because we've been on the air 100 years. So what you got to understand is that when you sign a contract, you should always get a copy back so that you can show the judge, this is what I signed, and they've changed the deal, if that's really the case.
If someone comes inside a store I work at and refuses to wear the mask, do I have the right to take the person by the arm and put him outside?
A private business can run their business, their store, any way they want to in terms of how they're going to serve people, who they're going to serve, what they're going to require you to wear when you come inside, how they're going to have you behave when you come inside, as long as they don't run afoul of our fundamental civil rights laws and exclude people or pick on people because of race, religion, gender, and the various categories that apply. The problem I see with this idea of just grabbing them by the arm and throwing them out is that some people can't wear a mask because of medical conditions and the like.
That's the problem. It's not the grabbing them by the arm part that's the problem.
You escort them out.
You don't grab them by the arm. You call the police.
That'll do it for this session of the People's Court. We'll see you next time.